So yes, to alert the court to the two headline points that I'll be addressing now after the lunch adjournment. Firstly, focusing on the adequacy of the reasoning in relation to the conclusions in respect to the bites, and secondly then to move on to the lack of a finding in relation to the ear. On behalf of the children, I submit that those are the principal failings that would lead this court to potentially vitiate and set aside the judgment as matters stand. And I hope to do that by reference, as my lords have been consistently asking, by looking at the judgment itself to see the task that was set of the judge and how far she discharged that function. So I think in relation to the first of those issues, I think it may assist to start on the legal framework that the judge sets out, just to draw a couple of points. That's at 47 within the core bundle. I think it may be electronic 50 if I'm not working for that. And of course, that starts with my Lord Justice Baker's a reference to the summary provided when Mr. Justice Baker in re L&M, which I think is certainly a convenient framework that judges and practitioners use.
Well, I noticed actually before we got to that the judge was provided with, the recorder was provided with a very helpful legal summary from, no doubt, from Miss Jones.
Yes.
And from which this is extracted.
Of course. And I should condition this in saying, and I accept in absolute terms, there is no criticism of the legal self-direction that's given. It's merely that this helps amplify the task that assists. And my Lord sets out, which are quoted at paragraph 37, a number of different propositions, including the need for findings of fact based on evidence and inferences that can properly be drawn over the page, appropriate attention to the opinion of medical experts, but considered in the context of all of the evidence, and then critically at 7, the evidence of the parents and other carers is of utmost importance. It's essential the court forms a clear assessment of their credibility. To tie that in then to, and I think there has happily been a limited authorities bundle placed before the court, I hope not unhelpfully given the degree to which there's an acceptance of the well-established principles. But at A59, in the judgment of the Court of Appeal in Re A Children, it's a 62 electronically in the 96-page authorities bundle. Paragraphs 33 and 34 of the judgment of Lady Justice King. This is the judgment that disapproves of the gloss of not straining, but I think provides a helpful synthesis of what the court's task is. Paragraph 34, no longer directing themselves on the necessity of avoiding straining. The unvarnished test is clear, and this is the important consideration. It's a consideration of all of the evidence and applying the balanced probabilities. A judge either can or cannot identify a perpetrator. If she cannot do so, then in accordance with Re B, she should consider whether there's a real possibility. And whilst it is obviously specific to the facts of the case, it may assist the court to move forward to paragraph 42, which is 62, which is page 62 of that bundle, which notes that a failure in that case, which respectively may apply here as well, which is that upon identifying the individuals on the list, the only individuals who could have caused the injury were the parents. Unfortunately, rather than then moving on to consider whether the mother or the father had, on the balance properties, inflicted the injuries, the judge approached from the other end of the telescope, namely whether it was so improbable that he should be excluded as a perpetrator. So the first task and step is to, in my respectful submission, to consider whether the evidence in relation to each of the potential individuals on the list is sufficient to ground a finding on the balanced probabilities. I respectfully accept that, as the court has repeatedly highlighted, there are many different ways in which a judgment can be structured and considered. There isn't an absolute mechanical way in which that must always be approached. But I think the danger of not seeking to distinguish between the steps of an identification on the balanced probabilities and a move towards considering that globally as to whether you are moved towards a pool finding is that the conflation may not assist in the identification of the features that might be relevant to each of the individuals. And I'll come to that when I address the judgment, but I hope that assists in setting out the territory.
This passage of Lady Justice King's judgment was cited by the judge, of course.
Absolutely.
Yep. Paragraph 42.
Yes, and indeed, within the judgment at paragraph 45, the judge opens her consideration of the evidence by reminding herself that it's clear from the authorities I do have to form a very clear impression of the lay witness evidence of mum and dad in this case. I look at them together for the moment. Moving through the judgment, my learned friend on behalf of the local authority, in seeking to invite the court to be cautious about the ultimate conclusion reached at paragraph 66, alighted on the reference to being disappointed. There is obviously a context to that, in that for a very considerable portion of the proceedings there was a view that potentially the older sibling had caused the bite marks, and that would obviously lead to a potentially very different conclusion in relation to the impact of that on threshold if it was a child who had caused the injuries without intent, and it not being the fault or responsibility of the parents. And insofar as there appears to be a challenge to that ultimate conclusion at paragraph 66, the judge does herself explain at paragraph 53 why, even though that was maybe a striking phrase to use, in the final sentence of paragraph 53, I do understand and do temper that part of her evidence by the knowledge that actually the child was in and out of the frame through the course of these proceedings. My submission is grounded on the reality that when the judge does at paragraph 66, she does reach conclusions in relation to the mother and her overall impression of that evidence. She wasn't trying to lie or make things up. Notes that may be different to not recalling or saying things. And equally, the paragraphs that follow, which again bear careful consideration in relation to the father, plainly gave rise to a greater level of anxiety for the judge in relation to his approach to some of his evidence. And at paragraph 75, the judge notes how she felt driven to clarify what her role was in the case. So respectfully, there does appear, following the consideration of those two parents, those two critical lay parties, there does appear to be a distinction in what the judge has drawn from them as witnesses. And of course, the requirement that is summarised and encouraged by my Lord Justice Baker's decision, and that the judge has set herself a task of forming a view on credibility, isn't in the abstract. That is so that those findings as to credibility can be properly factored in at the stage at which the court draws the different strands, the totality of the evidence together, in what I think has been previously described as the engine room of a judgment, where the evaluation and analysis brings those strands together to seek to form a determination and a conclusion. And that, in my respectful submission, is where, when one moves forward in the judgment where the conclusions are arrived at, there appears, in my respectful submission on behalf of the children, a deficiency that in this case is very significant. So I wanted to turn forward then. My lords have already seen the consideration of the expert evidence, where that takes matters in terms of the injuries being bites, the bites being inflicted, that the bites were not caused by the older child. My lords have seen at paragraph 121 the quote from Mr. from the expert report, where Dr. Kubler is plainly drawing a distinction as to one of the key features of the case, the injury to the cheek, whether there is, on the expert evidence, a distinction that could be drawn. And the judge then goes on to record Mr. Sanders' submission. This is at paragraph 134, bottom of page 60. And paragraphs 134, 135 and 136 are very significant. The submission on behalf, as I understand it, of Mr. Sanders, is that medically that's enough to say, on balance, it's the father. That's recorded at paragraph 134 over the top of the page. The judge at 135 says respectfully, I disagree with that. And what does the judge draw from that medical evidence? Well, it might be more likely than not when you compare mum and dad directly. So, from the medical evidence, there is a preponderant likelihood that arises in relation to the father as opposed to the mother. Now, the judge has not accepted that is enough to determine the entire issue, but that is a significant distinction between the parents that falls to be properly evaluated. And the tension applies that where the judge doesn't sufficiently explain her reasoning and deal with that evidence is that it is not only if that medical evidence is sufficient in and of itself to establish on the balance of probabilities that the father is the perpetrator, that it needs to be factored into the analysis. It may, in combination with a range of other features, have been sufficient if the judge had approached it in that way. And critically, within the following section of the judgment, the judge never incorporates what she has taken from her conclusions in relation to the parents and their credibility to factor that in at this point. So one arguably has a preponderant medical evidence that might point to a greater likelihood one way than the other. And of course there is a fine line between where the experts get to, which is not totally excluding the mother, but it being something that is, on any reasonable analysis of evidence, highly unlikely, as opposed to a very distinct position in relation to the father. But the judge doesn't disentangle where these conclusions, which come into tension, might draw her. Because by necessary implication, there must be an acceptance of the medical evidence that these have been non-accidentally inflicted. But at no point does she draw that together with, is that something that one or both of these parents are lying about? How does a conclusion that they might be lying about that factor in my earlier findings as to the credibility of the mother? And in that global analysis, is that sufficient to dispose of the issue of the bites in a way where she might have reasoned it to the point where there was a pool finding, but that has to properly evaluate the cases in respect of each of the parents?
Well, she's obviously dealt with the question of credibility earlier in the judgment.
Yes.
And why shouldn't this court assume that when she says, in paragraph 143, on the totality of the evidence, when I put the wider context into the frame, and I ask myself, who is on the list? Can I identify a perpetrator? And if not, is there a likelihood or real possibility they should be placed in the pool? I come to the conclusion that both of them are on that list. I cannot identify a perpetrator clearly, and there is a likelihood, etc. Why can't we assume that she's taking into account everything she's mentioned in her judgment?
Because those aspects which are critical to take forward, for example, the judge has raised the conclusion that the mother has not been lying, but that isn't the same as a lacuna of memory or not missing things. Does that account for why she doesn't remember a whole series of cries that would have been audible, how she explains the sequence of events? It also doesn't at any stage factor in any real engagement with the other evidence that exists in relation to who took photographs, who presented the children, who supported their being taken to the hospital. All of those factors are, I accept, referred to in the course of the judgment. There is a general reference to on the totality of the evidence. But where I respectfully submit that the process breaks down is that the judge's primary task was to seek on the balance of probabilities to identify a perpetrator. It's only if that cannot take place that one moves to a pool finding. And in this, those processes seem to be substantially conflated in the critical evaluative section of the judgment in a way that doesn't assist this court in disentangling how the judge has ascribed weight to the different competing features in the manner that is required of her by the case.
I have to say, speaking for myself, I would deprecate such an approach. Certainly if this court required it. If judges choose to express themselves in that way, I would not necessarily criticise them for doing it. But I don't think there's any one template about how you express your reasoning. Look, for example, at paragraph 139.
Yes.
Now, whether anyone in this courtroom agrees with that or not, that's the judge, as I see it, taking a real-world approach to all the evidence before her. It's the evidence of both parents. It's not even controversial. Dad effectively was not alone with these children. Mum was. So she faces a real dilemma, factually, which is the person who's with them pretty much all the time. The medical evidence appears to be on balance, not in favour of saying that it's mother.
Yes.
The medical evidence seems to point to father. But she says, I've taken into account all the evidence. She says that not only at 143, but also in the middle of 135, for the surrounding reasons and the evidence that I have as a whole. I do not think these pieces of medical evidence get to a stage where I can say on the balance of body, there is a... Now, you can disagree with that. We could disagree with that. But that's not the test for allowing an appeal.
I respectfully entirely agree, and I conditioned the starting point of my submissions in saying there isn't a one way to address a judgment. I'm not seeking to encourage this court to employ that approach. What I think arises in this case is that the merge structure that comes from the judge's ultimate conclusion is one that doesn't assist in disaggregating out the features. And so the fundamental finding as to, for example, the mother's credibility doesn't get factored in at a point where, yes, the mother may have limited...
Why do you say that?
Because in engaging with the evidence of both of the parents, the judge has to confront that there is obviously a
your
denial.
proposition has to be that because she hasn't mentioned it again here, she's forgotten about her findings on credibility. That's not a proposition that I would readily accede to.
I'm suggesting that where the judge is facing aspects of evidence that come together that are difficult to reconcile, that one of the critical factors that she takes forward is where does the credibility findings in relation to both of the parents take her and get factored in at that point.
I could understand your submission more readily if she had come to the conclusion that there was one perpetrator. If you're going to do that, I can see how you could say, well, I've got this strand, I've got that strand, I've got the other strand, I'm discounting this strand. So the sort of analysis that you're talking about. But not where the conclusion, one putting them all in the mix, is I've got a pool, or I can't exclude either. So it seems to me in those circumstances, the sort of level, what she's done is she's identified the things that weigh with her, one way or the other. She hasn't done a sort of seesaw on each thing. she's made clear what she takes into account. If you accept that she's not forgotten what her assessment of the witnesses was, to my eyes at the moment, the conclusion follows.
And my lord, I hope I have tried to assist in terms of analysing that approach. Plainly, it's for this court to determine whether the judgment sufficiently addresses what the judge is required to undertake by way of that evaluation of the parents. There is, I think, a number of points where this court has arrived at a point where there has to be a necessary inference or an assumption that something's been taken forward. And I understand that that is an approach that, of course, this court has to adopt to some degree in relation to a trial judge taking matters forward. That applies equally to having taken account of case law that is cited. But the engine room of that analysis is where the different strands come together, and that is ultimately the analytical consideration that this court has to give, factoring in the conclusions that the judge has made and how they reconcile here with the different strands. But as a global submission on this portion, the degree to which the court properly engages with how far medical evidence might point one way rather than the other is a point of weakness. Equally, the degree to which the court has properly engaged with the credibility findings is limited at this stage, except it's done previously, but how is that taken forward and balanced is the ultimate question that is for this court to determine as to whether this judgment is sufficient. And I don't approach this on the basis that the outcome is necessarily disagreed with. It's whether the analytical underpinning of the judge's approach is sufficient.
Right.
Turning to the other aspect of the other aspect of the decision in relation to the injuries to the ear. Respectively, one point that I would advance, which factors into both strands of the analysis, is that the judge does approach the different injuries in a way that is demonstrably compartmentalised.
Demonstrably what?
Compartmentalised.
You mean she considered the bite marks in a different compartment from the ear injuries, do you?
Yes. Because the entirety of the judge's reasoning in relation to the bites is concluded before there is any engagement at all with the separate question, as the judge frames it, of the injuries to the ears, or the injury to the ear. So, my lords can see at 145 that there are conclusions on the bites. It is a bite, it is inflicted, and the judge, the recorder, has made a poll finding in relation to that. Before one approaches the question of the ear injuries, in my respectful submission, these are themselves injuries that were dealt with a considerable degree of clarity in the expert evidence as to not only the seriousness but also the likely mechanism and the high probability of reflecting inflicted injuries. The infliction of those injuries, properly considered, might itself be a necessary component of the consideration of the totality of the picture that might or might not inform how the judge frames her conclusions in respect of the bites.
Did anybody submit that the ear injury demonstrated who the perpetrator was of the bites?
I think my understanding of the manner in which the evidence was analysed on behalf of the children was that part of the clarity emerged from the consideration of the April photograph, which was where the expert evidence reached its high point in terms of distinguishing potentially, to some degree, as between the parents, and that might inform the ear injury, but that may have been more open textured.
Sorry, would you just explain that a bit more clearly for my benefit?
I think the clearest entry point in one of the injuries having some independent evidence that distinguished between the parents is the matter relating to the bite in April that my lords
Which is
have
why
been
I was
taking.
asking you about the other way round.
Yes, but they are mechanically different injuries as to how they have been inflicted, whereas the bite marks are all a consistent mechanism. It is also plainly an injury that the expert evidence was saying were unusual and likely to have been very painful and likely to have provoked a significant reaction. Ultimately, there was an entire bifurcation of the consideration of the two discrete aspects of the injuries.
What effect has that had on the reliability of her non-finding about the ear injury, or her approach to the ear injury? You say she's dealt with it in compartments. How has that undermined her conclusion on the ear injury?
Well, the reality is that there is, and a separate aspect of the criticism that's advanced is a failure to make any finding at all in respect of the ear injuries. They are different in time, when they are presented, and how those have come about. So quite how the judge would have analysed matters would ultimately have been a matter for her to consider on the totality of the evidence.
The medical evidence wasn't that the evidence about the ear was diagnostic or pathognomic of inflicted injury, was it?
I think the expert evidence pointed very firmly in the direction of an inflicted injury.
Sorry, say that again. Very
In relation
the
to the
direction of-
ear injuries, that pointed very firmly in the direction of those being inflicted injuries.
whether she accepts that.
Well,
She says it's unexplained.
so analysing this portion of the judgment, the judge addresses at paragraph 148 the possibility of the older child having caused those injuries, and reaches the conclusion at 149. At 150, the judge is saying it was a hematoma and an injury. The injury is unexplained, so it doesn't reach any definitive conclusion as to that is an inflicted injury, that is in any way a matter that is relevant to threshold, for example, that it is arising from some deficit of reasonable parenting on the part of one or other or both of the parents. The judge did, respectfully, I would submit, have a clear evidential base to consider the injuries to the ear, and of course, again, in the dynamic process of considering the totality of the evidence, one aspect of potential weakness is that in the consideration of those injuries and leaving them unexplained, the judge doesn't factor in the injuries in relation to the bite marks and consider how, if at all, they might have impacted. Now,
so really what you're saying is this, is that where, instead of saying, in light of the remaining findings in the case, I need say probably no more about that, she should have said more about it before she came to any findings about the totality of the injury. Is that what you're saying?
well, I accept that on a practical level, the judge has to find an entry point somewhere, and writing is a process that follows sequentially. But the expectation is that the judge has to consider and weigh the totality of that evidence and consider how potential findings might interact with one another. And so, for example, if a judge has found that, as here, there were a series of bites that were inflicted, how does that not in any way factor into the analysis that given there is strong medical evidence as to that being an injury that is inflicted, the judge has ruled out the older child, how at that stage does it not become relevant that there was, on the judge's finding, at least one of the parents who had inflicted a range of bites? So the way in which the judge deals with matters in distinct compartments means that the impact of the totality of the evidential picture is lost. How that factors into the findings at different stages is ultimately a matter that the judge would have to balance. But on the other end of the telescope, if the judge has reached clear findings in relation to inflicted perpetration of bite marks, the judge, in cross-checking the findings, would have to consider how she has left the process in relation to the injury to the ear attenuated to the point where she says it's unexplained and I need to say no more about it. And that, respectfully, does not appear to engage with the direction of the medical evidence that related to those ear injuries or the other findings.
Was any party making an assertion that I think the Lord may have asked us already, forgive me if he has, was any party making an assertion that the evidence about the ear injury assisted the identification of the perpetrator of the bite marks?
I think I had responded in that the clearest evidence flowed the other way in relation to the odontology in relation to the April bite mark, rather than there being a feature that
So is the
allowed a
answer
ready
no?
distinction between the parents.
Forgive me, is the answer no?
Yes.
Thank you.
So in those circumstances, how does the judge's omission to go further than she does at 150 justify this court interfering?
Well, the local authority frames its grounds of appeal on the basis that there was clear evidence that would have sustained a positive finding in relation to the ear injury.
That it was an inflicted injury.
Indeed.
But not as to perpetrator.
It may not have been possible to identify a perpetrator, but the local authority's case is that there was sufficient evidence to ground a positive finding that those were inflicted injuries themselves. And of course, in addition to the expert evidence that existed, there were then findings in relation to the bite marks that suggested there had been other physical harm inflicted on the child.
Can I just pick up one other thing?
Yes.
There's always two ways of reading a judgment. One is to see if you can pick holes in it, which is normally pretty easy at some stage. The other is to look for the coherence of what's going on. And this recorder has clearly tried to provide a coherent line of argument leading to conclusions. If we look for the coherence in paragraph 150, can I suggest that it is actually quite obvious what she's saying. She's saying, I've got a pool already. I can't add to that pool or subtract from that pool by reference to the ear. It's not necessary. It's not beneficial to say anything more about it. Now, if your submission had been that the ear was critical to the identification of the biter, or indeed vice versa, I could understand that there would be some substance in your submission, but at the moment, that's not what you're saying. You've just confirmed to my lord that that's not what you're saying. And so I don't actually, it's probably my fault, but I don't understand where this submission goes.
I think that the reality of the local authority's appeal is that this was another aspect of significant harm that had been suffered by this child, that there was evidence that plainly sustained that finding. And if my lord views it in that way, which is similar to the judge, that essentially if the ear took the question of the bites no further, then it wasn't independently relevant, ignores the fact that that is an additional element of significant harm that is well evidenced and grounded on the expert opinions, and itself, on the local authority's appeal, which respectively the Guardian agrees with, would have justified a finding. I know the other aspect that I think my Lord raised was whether the subsequent paragraphs in the conclusion might allow a fair reading to be that there was, in fact, a finding in relation to the ears, or to the ear injuries. At paragraph 150, it appears respectively clear that there hasn't been a finding made, and when one examines the conclusions at paragraphs 151 onwards, the conclusions in relation to what finding has been extracted seem plainly to alight on the bite marks rather than to suggest that there is that there is a positive finding in relation to the ear injury. But the judge was obviously considering an aspect of harm which may have been independent of the bite marks, may have been caused by the same person or a different person, and may itself be a factor that adds to the overall assessment of not only the harm suffered but the risk that might arise.
Was anyone contending before the judge that the perpetrator of the bites may have been one person and the person who caused the injury to the ear was another person?
There was certainly a submission made, as I understand it, probably most forcefully on behalf of the mother, that where the court was capable of identifying the perpetrator of the April bite mark, that there was a force of logic that suggested there might be a broader conclusion as to the perpetration of the bites, and logically, if there are 6 bites that are inflicted, that may factor in, I suspect, to the perpetrator of the ear injuries. But I don't understand it to have gone the other way, which I know the Lord has sort of clarified.
Thank you. Thank you very much. Right. So that's the ear injury point.
Yes, I think identified that whilst the failure to protect is dealt with in a fairly brief fashion, I accept the point that in circumstances where, unless there is a fundamental acceptance that there is a deficiency in the judge's analysis of the primary injuries, there is a lack of clarity as to what has happened to cause the injuries beyond those findings the judge makes, that they are inflicted and bite marks. To that extent, there is a difficulty in disaggregating exactly what the nature of the failure to protect is. It was a matter that was raised on behalf of the Guardian and is not, as the court is aware, to be treated as a bolt-on or adjunct. I don't submit that a deficiency in relation to the failure to protect of itself infects the judgment more broadly to the point where that judgment could be set aside flowing from that one discrete ground.
What was the failure to protect argument advanced by the Guardian, referred to in the penultimate sentence of the judgment?
It rested on the knowledge of the injuries having happened and the failure to take action to proactively address them. Of course, the judge, in a relatively brief consideration of the issues, expresses some anxieties about some aspects of the evidence. There is obviously evidence that cuts in different directions, bearing in mind the possible identification of the older sibling as the cause, which again may have led to a lesser degree of concern. But again, particularly if my lords are attracted to the argument that has given rise to the issue around the ear and the degree to which it behoved the judge to make a clear finding in relation to that injury or not. Again, analysing matters through the frame of what was being taken forward, once there is a full finding in respect of the infliction of the bite marks, then both parents, for the purposes of that future assessment, have to be considered as potential perpetrators of the actual physical harm itself. And to that extent, again, especially given the manner in which that failure to protect evolved in the course of the proceedings, but in particular the hearing, the degree to which the judge felt able to capture that or felt it was relevant may fall to be considered. I have sought, in the course of the document that I put before the court, to locate that as a further area where there is a deficiency in analysis that goes to a broader concern about the coherence and sufficiency of that analysis, rather than that being fatal of itself. I know that the court explored how, if the court does retain anxiety in relation to the failure to protect issues, that might be dealt with. It may be challenging for the learned recorder at now 3 and more months distance from having heard the evidence and drawn such conclusions as she did, to seek to revisit that to amplify what is said in relation to a potentially complicated issue of failure to protect at this stage. And it may be that can be captured or considered as part of any subsequent process of assessment that looks at. There are obviously findings that are made about the inflicting of bites, and that may be something that can be considered with the parents as to their responses to that and how they took matters forward. And it may be something that can be considered in the course of any welfare evaluation at a final hearing.
Is there any substantial disadvantage to the assessor from the fact that there's not a sentence in the judgment that says anything about failure to protect, no decision about failure to protect? Why can't an assessment be simply commissioned to answer the question, does this mother or father have the capacity to protect the children?
And that, I suspect, comes down to the analytical distinction between having considered it and making no finding, a 0 on the binary principle, or having left the territory open, which may be one reading of the limited consideration that the judge gives. If there is a nil return as opposed to a non-finding, does that make a distinction as to the assessment phase that can follow? My lords, in relation to disposal of the appeals, in the event that my lords consider the judgment is sufficiently deficient to necessitate that the findings are set aside, what I've indicated is that there should be swift consideration of case management, and in particular consideration of whether the matter should be dealt with on a standalone basis or whether it can be dealt with on a composite basis, that being the original intention of the hearing in March in any event. And it may be that is an appropriate means by which to prevent an accumulation of further delay. In the event that the appeal is allowed, it would obviously, in my submission, not be appropriate for the matter to return to the learned recorder. In the event of the appeal being refused, or obviously the possibility of some partial acceptance of the case advanced by the local authority, my lords will have to consider the degree to which that might be said to preclude further consideration by the learned recorder. I'm not sure whether we are in the territory, given that the recorder came in to deal with that fact-finding hearing alone, that it would necessarily be possible, albeit obviously there is a desirability in the generality for a fact-finding to be taken forward to a final hearing by the same judge, but whether that allocation and the recorder sitting as a recorder is sufficient and she is available is a matter that would obviously have to be considered by the judge allocating matters. I'm not sure my read on it was that the recorder necessarily anticipated having any further involvement post-fact-finding,
Yes.
but obviously in terms of understanding the nature of what was taken forward from those findings, that would no doubt assist. And equally, I've highlighted the expectation that if there is a fact-finding decision that is made, that ordinarily there should be a process whereby the findings that can be extracted from the judgment should be crystallised, that may be a process that is more amenable to taking place now on the basis of the transcript of judgment and in consultation with the judge than, for example, revisiting for further or other reasoning as to aspects of the findings that were made or not made.
And if the appeal were dismissed, is there anything you wish to draw to our
Apologies, I was addressing the circumstances where the appeal was dismissed or allowed only on a narrow basis.
I see. Right.
If the appeal is dismissed, then these are the findings, for good or ill in terms of the assessment process, that are taken forward. I have not sought in the presentation of a case on behalf of the children, albeit there is an acknowledgement that, as compared to a sole perpetrator finding, a pool finding makes the risk assessment process more complex. But the mere fact that a set of findings might make that subsequent process more complex, if that is properly or sufficiently for the court's purposes justified, then that is what is taken forward into the risk assessment process. So I'm not sure that the mere fact that findings may be less convenient or less optimal than another set of circumstances would justify the appeal. That appears to be addressing matters on the wrong end of the telescope.
Mr. Barnes, thank you very much.
Thank you. The only other matter I have sought to address the question of delay in writing. There are a number of strands that seem to have coalesced. All I can say from the perspective of those instructing me and the Guardian is that they have sought throughout to draw to the court's attention the difficulties that were arising in order to comply with their obligation. It is ultimately an obligation on all parties to cooperate with the court to achieve the overriding objective of achieving outcomes without undue delay. Thank you.
Yes, Ms. Jones.
My Lord, yes. I have nothing to add, having heard the submissions from other parties, unless there is anything you wish me to specifically address.
Yes, what we will do now is rise for a few minutes to consider the next steps.
Of course, Lord.
Okay.
You've got them.
I've got
Karen, I don't know how you did what you just did with the bundle situation, but amazing. So the only thing missing out of yours was my opening,
I've got
which is
see
fine.
the
we can
yellow.
add.
See, this is the April bundle. That's
Yes,
what I've
we've got all the. Can you click on that and see what the date's on that one is, please?
Oh,
Oh yeah, so I think we've got
they've
Got that one as
21st
well.
of February.
but
I've got the 21st of February here.
Okay.
So
but
I've
Joanne, you pointed out that there would be an early on the C.
It's really detailed in the C11A, and it's what Mum responds to, and it's what Dad responds to.
Right.
I've done a chronology.
I saw the
Look at this.
chronology.
You've seen this box response document?
Yes.
Yeah,
Yeah,
so
I've
that's
got
in
that.
there as well. If
Yeah.
you put it, I don't know, can we put that chronology into the document, because then we can follow.
Well, we could send it, even if it is sent separately, it doesn't matter.
I'm just
As long as it's all together,
Yeah.
chronology, then bundle, and even if it's my opening going separately, it doesn't matter. But the C,
It's all coming back to me. Amjad did one, didn't he?
that's in as
I
well,
did
don't
one,
worry.
And your parents didn't respond to that.
No. Joanne, I can't see. You sent me an email saying the C110A needs to go in there too, please. And I couldn't see that attached, but I could see
No,
a
I haven't.
chronology.
I've got that.
You've got it.
I've just extracted it.
I can't
Amazing.
extract anything.
Amazing.
What?
How did she extract it?
So what happened was,
Some
when
of
I had
Well, we're very grateful to all concerned, including those who are not present in the courtroom. We are going to reserve our judgments Drafts will be circulated in due course to the people whose details were supplied before the hearing, so that they can draw our attention to any typographical or minor factual errors and agree a draft order so far as possible. If that's not possible, then they can file written submissions, so an order can be finalised at the same time as hand down, which will take place in a normal way remotely these days. Can I emphasise, particularly for the benefit of those who may not be familiar with this court's processes, that there is a very strict confidentiality embargo when the draft judgments are circulated, and this court takes extremely seriously any breach of that confidentiality. I'm going to check with my lords if there's anything else before we go. Thank you all very much.
My lords, could I just raise apologies? One point, you did ask for some additional documents.
Yes, we did.
We have endeavoured to try and extract and put them all together. We are close to having that in its final format for you.
Thank you.
If we can send that in today, and then you have that ready for your.
That'd be very helpful. And if you
apologies for the delay with that.
Yeah, if you could send them to the to our clerks.
Miss Whitby, my clerk, is the
Of course.
lead clerk.
That's fine.
Thank you very much.
Then it'll be circulated to all the members of the court.
Of course.
Thank you very much.
Thank you.